Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. These are the first arguments in over 11 years at which Nathan Hecht was not the Chief Justice. And these are the first arguments in over 36 years at which Nathan Hecht was not a member of this court. On behalf of every member of this court and on behalf of the entire judicial branch of the state of Texas, I want to express our deepest gratitude to the Chief Justice, the former Chief Justice Nathan Hecht, for his leadership, his friendship, and his extraordinary legacy of service to this court and to the people of Texas. We would also like to welcome the court's newest member, Justice James Sullivan, who is with us this morning for the very first time. Chief. With that, we'll hear argument in 4 cases this morning. The first is 23-0384, American Midstream versus Rainbow Energy Marketing Corporation from Harris County in the First Court of Appeals District. Justice Devine is not sitting in that case. The second case is 23-0662, Rager Corporation versus Myers from Dallas County in the Fifth Court of Appeals District. The third case is 24-0573, Paxton and the State of Texas versus Annunciation House, a direct appeal from El Paso County. Justice Sullivan is not participating in that case. And finally, 24-0759, American Pearl Group and others versus National Payment Systems, a certified question case from the United States Court of Appeals for the Fifth Circuit. The court has allotted 20 minutes for each side in each of the cases, and we'll take a short break in between the arguments, which are being webcast live this morning and will be available on the court's website later today. We're ready for argument in 23-0384, American Midstream versus Rainbow Energy Marketing Corporation.
May it please the court, Ms. Vaughn will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. Unless the court directs me otherwise, I will focus on 2 cross-cutting issues in this appeal: contract construction and damages, both of which independently require reversal. Turning to the first issue, this case rests on a threshold contract construction error that infected all of the trial court's liability findings. The trial court explicitly rewrote Section 9.1 of the parties' MAG 5 agreement to insert the term scheduled. As the dissent found, that error radically altered the parties' contract. Because while Rainbow's scheduled receipts and deliveries were always in balance on the Transco pipeline, Rainbow's physical receipts and deliveries were out of balance on the Transco pipeline anytime it used the MAG 5.
Were both of these parties responsible to determine whether or not there was an imbalance?
There was an imbalance as a matter of law under the terms of the MAG 5, because what Section 9.1 gave Rainbow was the right to submit a nomination for the delivery of gas to the Transco pipeline without actually physically putting any gas into the Magnolia pipeline. So because it didn't physically put any gas in, no gas is physically flowing into the Transco pipeline. And then when Rainbow makes a nomination to withdraw gas from the Transco pipeline in Zone 5 to supply to its customers, that creates a physical imbalance between the amount of gas that is leaving the pipeline and the amount of gas that is entering the pipeline.
And so I assume there's engineers, experts who know how to determine this, because obviously if there's an imbalance, there could be a rupture, an explosion, bad things would happen. And so that's what I was trying to understand exactly. Are there experts on both sides of this that are making that determination, or is it totally on the part of the pipeline or on the gas company?
So there is a physical meter at every interconnect that measures the amount of gas that's flowing across the pipeline. So Transco can see, a certain amount is nominated into the pipeline, and it can look at the meter in real time and know that less physical gas is flowing than is nominated. And that physical imbalance is the whole point of the Mag 5, right? Because again, Rainbow wants to pull gas physically out of the pipeline on cold days when the price of gas is at a premium, and then put gas back into the pipeline on warmer days when the price of gas is lower. Once that threshold error is fixed, it knocks out all of Rainbow's claims, because there was a written operational flow order or critical alert limiting imbalances in effect on all but one of the 7 specified breach days in the trial court's findings. And those operational flow orders and critical alerts triggered Section 9.1 as a matter of law.
So it appears that Rainbow's business model was to take advantage of a market inefficiency. And then Transco, not a party to the Mag 5, said, we've recognized this inefficiency, and like other actors in the market, it decided to cure the inefficiency through an operational flow order and using those more frequently. So who bears the risk that Transco is going to discover and rectify the inefficiency that Rainbow sought to take advantage of?
So Rainbow bears that risk under Section 9.1, right? Because anytime Transco requests or requires the parties to balance the receipts and deliveries of gas, then Rainbow cannot use the Mag 5. So it's very clear, Section 9.1 puts the risk of an OFO squarely on Rainbow.
Even if your client could have rectified a physical imbalance by itself, introducing more gas into the pipeline.
I mean, it's theoretically possible, but there is no contractual obligation in the plain terms of the Mag 5 requiring us to do that.
So there's no makeup provision.
No, we have no obligation to physically deliver any gas under the Mag 5.
Does it matter who Transco requests or requires to balance the receipts and deliveries? So the first exemption says you can't, AMIT doesn't have to accept Rainbow's out-of-balance nominations if either AMIT or Rainbow is requested or required. And does it make any difference if Transco directs that request to one or the other? Could it direct the request to Rainbow, directly to Rainbow?
Yes, and in fact, that's what it did in this case. All of the OFOs in this record are directed to Rainbow. But if they had been directed to American Midstream, they would qualify as well. So it's any request or requirement to either American Midstream or Rainbow.
But your position is who the request is directed to doesn't affect who bears the burden or the risk here.
That is correct. Rainbow, under Section 9.1, bears the risk that Transco is going to limit imbalances regardless of whether or not Transco directs that request to American Midstream or Rainbow.
Let's say we accept your position about the applicability of the OFOs. Does that mean that you concede that there was a breach on the day in which there was no OFO?
No, absolutely not. And if you'd like to turn to tab 3 of the bench exhibits, I can walk you through that day. It's November 22nd of 2016. So this is the written instant message that was exchanged between the parties' gas schedulers on that day. It is the sole basis on which Rainbow claims that there was a breach on November 22nd. The party in green here is a Rainbow gas trader. The party in blue is an American Midstream scheduler. And I'm paraphrasing, but as you can see, Rainbow reaches out and says, "What's the most I can put back into the mag tomorrow?" American Midstream says 15,000 decatherms, and Rainbow states, and I quote, "Cool, thank you." That's it. There's no complaint. There's no objection. There is no nomination for service under this contract. There is not even a bare request to use more than 15,000 in balancing services that we freely offered. And we know what happened on the next gas day. Rainbow nominated 1,600 decatherms of gas, far less than the 15,000 we freely offered. So there is no evidence of any breach on that one outlying day, November 22nd of 2016. And again, there is a written operational flow order or critical alert in effect on all of the remaining breach
Why
days.
isn't it a breach to say I can't perform to 20,000? 15 is the most I can do. Why isn't that a breach?
Because under Section 8 of the Statement of Operating Conditions, which are incorporated into the MAG 5 by reference, in order to get service under this contract, Rainbow had to submit a nomination. And this instant message is no evidence that Rainbow submitted a nomination and that we refused to provide service. In fact, Rainbow submitted a nomination for 1,600 decatherms, and it's undisputed that we confirmed that in full.
Section 9.1 calls for these to be an imbalance that's attributable to Rainbow. And if I understand correctly, the OFOs that did go out, it looks like they painted with a pretty broad brush, and they kind of applied to everybody, including Rainbow, is the position. In what sense was the request from Transco attributable to Rainbow?
So attributable means to ascribe to someone as the cause of something. So it means an imbalance that Rainbow is a cause of. And I can walk you through the terms of the OFO if you'd like to turn to tab 2 of the bench exhibits. This is an example of one of the operational flow orders that was in effect. They're issued on different days, but they're otherwise virtually identical. So as you can see, although the dissent would have reversed this judgment, she would have remanded for a fact issue on that question, Justice Sullivan, as to whether or not these OFOs applied to Rainbow. They apply as a matter of law, and you can determine that by looking at the plain terms of this OFO, right? Her concern was that the box for affected shipper was left blank. But if you look at the footnote, you can say, it says, if specific DUNS numbers, and a DUNS number is a unique 9-digit identification number that is given to every shipper on the pipeline. If specific DUN numbers have been identified, only imbalance created by those shippers or OBA parties will be subject to the OFO penalties.
I believe your friend in opposition says that the box 2 down from that where it says OBA subject to OFO, no. There's a suggestion that that might be appropriate for fact-finding on remand as to whether that would apply based on the OBA that Rainbow had with Transco. Is that right?
Right. So there are 2 limitations in Section 9.1, 2 sentences, right? The first is a request or requirement directed to Rainbow. The second is a request or requirement directed to American Midstream as the OBA party. So we agree this OFO does not apply to OBA parties like American Midstream. So that second exception in Section 9.1 is not triggered. But regardless, because this OFO applies to Rainbow as a shipper on the pipeline, it triggers that first limitation in Section 9.1.
So there's a lot of discussion of repudiation in the Court of Appeals and in the briefing. I wonder whether when both parties claim to be following the contract and have different understandings of what it requires of them, are we talking about repudiation in that instance, or are we just talking about breach? I mean, does the party who ends up being wrong about what the contract means, have they repudiated the contract? Is that the right doctrinal concept for us to be talking about here?
Absolutely not. And I think this court's opinion in Saunders goes to that, right? If it is a statement that is based on a misinterpretation of the contract or a misinterpretation of the facts, then it cannot be a repudiation. And here there is no repudiation because the trial court's finding of repudiation was premised on her misinterpretation of Section 9.1, right? She determined that none of these OFOs in the record could excuse American Midstream from performing, okay? But once that is corrected and all of these OFOs apply as a matter of law, there is no statement in that December 7th phone call that could even remotely be construed as a clear, absolute, and unequivocal refusal to perform, right? Because as the dissent found, once you fix that contract construction error, all of American Midstream's statements on that call were simply invoking its rights under Section 9.1. So no evidence of a repudiation in this case, once you fix that threshold contract interpretation error.
You had mentioned that you wanted to speak with us some about damages here. If we agree with your construction of Section 9.1, does this court need to say anything about damages? And do you want to hum a few bars for us on the reasonable certainty test?
Now, if you adopt our interpretation of Section 9.1, again, that nixes out all of Rainbow's liability claims, and you don't need to reach damages. Damages does provide, however, an independent ground for reversal. Rainbow's high-risk, hindsight-driven lost profits model does not meet this court's reasonable certainty standard. The model has absolutely no historic grounding. It is undisputed that Rainbow has never implemented this model in its 25-year history, including during the 10 months the MAG 5 was in effect before there was even an allegation of breach. And there is no evidence that any energy trader in this entire industry has ever implemented this model.
How do you respond to your friend in opposition? They said that the course of practice under the MAG 5 was based on Rainbow, crawl before you walk, walk before you run, so that what happened under the year that they did do some nominations that were honored under the MAG 5, they were really just kind of kicking the tires.
I think Rainbow still has to point to some objective evidence establishing with reasonable certainty that it would have implemented this highly risky strategy, okay? And there is no evidence in the record to support that. In fact, all of the objective evidence in the record shows that Rainbow had never implemented this strategy and never would have, because this strategy in a bad winter, it could have lost Rainbow $7 million. It could have bankrupted the entire company, right? And Rainbow's historical practices show it never would have undertaken that risk.
Any other questions? Thank you, Ms. Fawn. We'll hear from the respondents.
May it please the court, Mr. York will present argument for the respondent.
Mr. Chief Justice, may it please the court. Alan York on behalf of Rainbow Energy Marketing. The trial court entered appropriate findings of fact and conclusions of law and an appropriate final judgment based upon the evidence and specifically the agreement of the parties. A majority of the Court of Appeals affirmed that judgment, and Rainbow asks this court to affirm the lower court's actions. The biggest issue that we start with, obviously, is contract construction. And I don't think that there is any question, even between the parties, that under this court's precedent, it is fully appropriate for the district court to look to trade custom, the course of dealing between the parties, to inform the meaning of terms within a contract. We also agree that the trial court cannot use those things to add or change terms to a contract. But in this case, Judge Garrison did exactly what this court's precedent allows. She looked at industry and custom trade practice. She looked at the practices between the parties to inform the meaning of receipts and deliveries within the MAG 5. And in order to understand why it's true that that's exactly what she did, we have to take a quick step back, because in its argument, AMID made a statement that really is the starting point of the error of their argument when they said that any time Rainbow used the MAG 5, they were physically out of balance on Transco. That's simply incorrect. And if I can point the court to our first oral argument exhibit, it's important to take a step back and realize exactly what Rainbow was purchasing from AMID and what AMID was selling to Rainbow under the MAG 5. Because under the MAG 5, again, at the interconnect point between the Magnolia Pipeline and the Transco Pipeline, AMID had a right to an operational imbalance under its OBA with Transco of 5%. It was leveraging, to Justice Bland's point, a market inefficiency and monetizing that and selling that imbalance right to Rainbow.
Yes, but the problem with leveraging, is that the word used, a market inefficiency, is that the other actors in the market eventually also recognize the inefficiency and bring the market back to equilibrium. It appears that's what happened here.
And that's exactly correct, Justice Bland. But it's also important to point out that there are two sections of 9.1, and it is the second scenario of 9.1, which is a single point imbalance, that is implicated when that happens, when Transco notices that marketing inefficiency and does something to take care of it. Because again, what AMID was selling to Rainbow was a right to actually claim physical flow at the interconnect based on its right to be out of balance at that interconnect point. But if there is an imbalance at that interconnect point between what AMID is scheduling and physically delivering, that's a single point imbalance. And it's important that in this case, it is absolutely uncontested that everyone agrees that a single point imbalance was never implicated. Justice Sullivan, you pointed out that the OFOs specifically excluded OBA parties. Why is that important? Because only if the OBA party was included in the OFO would the single point imbalance be implicated. So in other words, what we're talking about here is pretty functional. What Rainbow purchased was the right to be out of balance on the Magnolia pipeline, not the Transco pipeline. Anytime Rainbow used the Mag 5, it claimed physical flow at the interconnect point, in other words, gas that was actually flowing. Under its pooling agreement that it had specifically and directly with Transco, it had to nominate a delivery point that matched whatever it was claiming at the interconnect point. And so, as the trial court found, the physical balance attributable to Rainbow was always present on Transco. When it operated under Mag 5, it claimed physical flow. Under its pooling agreement, it nominated an equivalent delivery point. Rainbow was always in physical balance on Transco.
It's your view that Section 9.1 just never would come into play.
No, Your Honor, that's not true. Because just as the court found, there was at least the possibility that a scheduling imbalance could have occurred. Let's take, for example, the possibility where Rainbow claims under Mag 5 a physical flow at the Transco Magnolia interconnect, but then it nominates a delivery that is either more than or less than at a delivery point downstream. That would create a scheduling imbalance. It could happen. But under this particular situation, because of its pooling agreement that it had with Transco, that didn't occur. Its nominations for the claiming the physical flow at the interconnect and its delivery points did always match up. It's another reason, Justice Sullivan, that even under the OFOs that were claimed here, the Rainbow, AMID is taking too broad of a view of those OFOs, saying that if there was an OFO in place, that gave them an excuse under 9.1. But you have to look at the actual terms of the OFO. An OFO was only applicable to parties who were out of balance. In other words, what it was saying is if you're out of balance on Transco, you have to come into balance. Now, let's back into that again. We know that under the use of the Mag 5, there might have been a single point imbalance, but everyone agrees that's completely irrelevant to this case. It had to be the first sentence of 9.1, which is a point-to-point imbalance. Rainbow was claiming physical flow at the interconnect. It was nominating an equivalent amount going to a delivery point. There was always balance on Transco. And so its use of the Mag 5 under the facts of this case did not create an imbalance on Transco that would have been subject to an OFO. And so AMID's, and by the way, let me point out that this is not a position that Rainbow has come up with. This is not a position that Rainbow has created for purposes of appeal. This is AMID's position. And in fact, if we look to specifically from the outset, we have a series of instant messages that were quoted in our briefing where Mr. Formel, who also subsequently testified as the corporate representative for AMID at trial, specifically stated in an instance that they were limiting Rainbow's ability to claim gas at the interconnect, but 45 minutes later came back and said, oh, our fault, sorry. The OBA party has not been brought into the OFO, therefore that OFO doesn't impact your ability to use the Mag 5. And that was reiterated by Mr. Formel when he testified at trial as AMID's corporate representative, and specifically said that, again, an OFO that did not pull in an OBA party had no impact on Rainbow's ability to use the Mag 5. Why is that? Because, again, what Rainbow was purchasing was the right to leverage against AMID's ability to have a physical imbalance at the interconnect between physical quantities and scheduled quantities. But what is that? It's a single point imbalance. And everyone agrees that single point imbalances were never implicated in this case. There is not a single OFO that was presented at trial, not a single OFO that has been cited in the Court of Appeals or in this court that pulls in an OBA party. Single point imbalances were never implicated. And by AMID's own concessions, both prior to trial and at trial, that meant that the OFOs that were issued had no impact on Rainbow's ability to use the Mag 5.
So this is clearly a situation in which reasonable minds can differ about how to read this contract and how the facts apply to the way you read this contract. In a situation like that, can it ever be correct to say that the party that turns out to be wrong about what the contract means has repudiated it by taking the view that they took of what it requires?
Mr. Chief Justice, I would draw a line between two things, repudiation and breach. Okay? And I know repudiation can certainly be a breach. But I think that what you're discussing, which is the parties' differing interpretations of a contract, we all know that that in and of itself does not create an ambiguity in the contract. We still look to the language of the contract, and if it's unambiguous, then it's interpreted as a matter of law. If an interpretation as a matter of law flows in favor of one party or the other, and one party has acted contrary to that, then I think that that does constitute a breach. The allegations of repudiation in this case go beyond a simple breach. And they specifically go to that December 7th, 2016 conversation that my opponent referenced in AMID's argument.
At which they took a position that seems to be consistent with what they're arguing here.
Well, I absolutely disagree, Your Honor. Let's look at the specifics of that December 7th, 2016 conversation. In that conversation, specifically, AMID informed Rainbow that the contract was going to be treated going forward as an interruptible contract, not a firm contract. What that meant was AMID was claiming the right to interrupt service at its will, as opposed to providing the firm service that was specifically guaranteed in the contract. It also specifically stated in that December 7th conversation that Rainbow could not use the Mag 5 more than 3 consecutive days. That's a provision that is contained nowhere in the Mag 5. And so those statements do constitute an absolute repudiation of Rainbow's rights under the specific terms of the Mag 5. Now, what AMID has tried to say and what the dissent said in the Court of Appeals below, excuse me one second. I've been on some sinus medication and my mouth gets a bit dry, I apologize. What AMID is trying to claim at this point, and what the dissent wrote below in the Court of Appeals, was that the statements made in this conversation were merely reflections of the excuse of performance provisions of 9.1 of the Mag 5. That's not true. Again, if you look at the specific statements that were made in that telephone conversation, they said that, well, what we're trying to do is we're trying to fly under the radar with Transco. If, in fact, what they had said was, we are going to continue to provide the service that is guaranteed under the Mag 5, but if there is an OFO that is issued that implicates scenario 1 under section 9.1, in which gas or an imbalance attributable to Rainbow on the Transco is implicated, then we won't be able to provide service. That would be a reflection of what the performance excuse is in section 9.1.
So are you saying that a disagreement about contract interpretation is tantamount to repudiation? appears to be the position you're taking.
No, Your Honor. I'm saying that under the specific statements that were made in that conversation, the statements that Ahmed was saying was, we are specifically not going to provide the service that we have guaranteed to provide under the Mag 5. That's not a matter of contract interpretation. You need only look to the actual statements. They're saying it's going to be an interruptible contract. The contract says it's firm. They're saying that you can't use the Mag 5 on 3 consecutive days. That exclusion is nowhere included in the Mag 5. So what they're
Did you nominate on 3 consecutive days and they failed to perform?
Your Honor, I don't know every single nominee. I don't have every single nomination, but I will say that, again, whether we did or whether we didn't, they are repudiating the specific terms of the Mag 5. And that repudiation, saying we are not going to fulfill our obligations under the Mag 5, and I would say, there again, we run into a little bit of a vagary here, especially when we start veering toward the damages argument. Because, Justice Sullivan, I believe you were the one that referenced the fact that we were going to walk before we run before, crawl before we walk before we run.
We'll do one of them.
Yes. And so the damage model here.
Well, the problem with that strategy, of course, is that while you're crawling, someone else is getting wise to what you're undertaking in this ecosystem of the pipeline, right? Someone's figuring out, oh, this is what they're doing. We're going to react to that by doing something ourselves. And so it seems as though, the money that got left was money that, perhaps could have been attained early on when the imbalance, the inefficiency was still there to take advantage of.
But Justice Flynn,
later, it became less easy to do that because another market participant said, no, we're not doing that.
And Justice Blunt, that argument would likely would probably crawl then walk then run better if the OBA parties were ever pulled into the OFO. But the inefficiency, the imbalance that we're talking about in that situation, again, is a single point imbalance. It's that difference between physical flow and scheduled quantities at the interconnect. That's what Ahmed sold to Rainbow, the right to leverage that. And it is absolutely uncontested that that single point imbalance was ever implicated by Transco. To your point.
Right, because the imbalance was ahead and behind, but not right at the point.
That's what we bought. And that's what we bought. But that distinction is important because, again, under the Mag 5, we never bought the right to be out of balance on Transco. And that's the important point under Section 9.1 is an imbalance on Transco. We bought the right to be out of balance on Magnolia. The single point imbalance, that was something that, to your point, if Transco had realized, oh, look, we see what Ahmed's trying to do here, right? And we're going to shut that market inefficiency down because they're trying to capitalize, they're trying to monetize on that. You know what all they had to do was? Include the OBA party on an OFO. But they never did that. And why is that important? Because as Ahmed, again, recognized from the outset and through its testimony of its corporate representative at trial, as long as that OBA party was not implicated in the OFO, it had absolutely no impact on Rainbow's ability to use the Mag 5.
Before you move on to damages, let me ask you one more thing on repudiation. Just accepting what your argument that you've made about it so far, why isn't the subsequent, after the conference call, the subsequent month-long performance by both sides in the same manner that you had been performing up until that day, a withdrawal or retraction of the repudiation and an agreement that you're going back to what you had been doing, or at least, until you could huddle up to figure it out. Our cases seem pretty strong about there's pretty low threshold for when conduct retracts a repudiation. So what's your response to that, and what's your best case on why this wouldn't fall into that bucket?
So I agree that this is an area that perhaps is not the most clear under the law, and I would probably disagree that the cases are as clear as what Ahmed has presented them to be. Certainly there are cases that say that if there is a repudiation and one party opts to require performance, that act of repudiation can be waived because the party has asked for performance. But those are situations in which there is a singular performance point. And this is the point that the majority opinion in the Court of Appeals made. That this is a different situation when we have a continuing obligation type of a contract. And the case that I would point the court to is actually a case from this court, which is the Glass v. Anderson case, 596 Southwest 2nd, 507, 512, a 1980 opinion from this court. That's a case in which this court looked at a situation where there was a repudiation. There was a request by the non-repudiating party that the repudiating party perform. And then there was a subsequent additional repudiation by the repudiating party. And that's the closest case that I've been able to find a situation where we have not a single act of repudiation, but an act of continuing breach. And that's what the facts are in this case, because even though the parties did agree to try to work out terms that might be amenable to both sides, we know that there was a subsequent breach, also in December of 2016, where Rainbow nominated 20,000 MMBTU and was declined. We also know that in January of 2017, when it originally nominated 20,000 and then didn't use the full 20,000, AMID came back and chastised Rainbow for not using the full 20,000 because if it had known that it wasn't going to, it could have sold that capacity to someone else. Now, this implicates the argument that we talk about also within the fraud findings, and I know we're not going to get into those fraud findings now, but it's important to make this point, that under AMID's OBA with Transco, it had a 5% imbalance right. The most it ever flowed through that Transco, through the interconnect, was 120,000 MMBTU per day. That means that it had a contract right under its OBA to a 6,000 MMBTU imbalance. What they were telling us in January 2017 is that even though you sold us a 20,000 MMBTU right, when you only had a 6,000 MMBTU right, if you had told us you weren't going to use it all, we could have sold that capacity and further oversold what we didn't even have a right to sell. And so in this particular situation, we believe that the ongoing acts of breach do change the character of when we can act on that repudiation. But at a minimum, those continuing acts would require consideration by the trial court in the first instance to determine whether that's a prior material breach separately that would have excused our continued performance under the contract.
Ms. De La Rosa is not a lawyer, is that right?
I'm sorry?
Ms. De La Rosa on the
That's
December 7th, not a lawyer, and so she did use the word interruptible, but rather than firm, I suppose. Was she even wrong there, given the language of Section 9.1? It seems like it was firm except when it wasn't, and able counsel on both sides is now joining issue on when it wasn't. But was she even wrong on December 7th when she said it's interruptible when Transco tells us it is?
Yes, she was.
Okay.
Because interruptible has a specific meaning in the gas business. And what interruptible contract means that the party who is providing the service can decline to provide service at its whim. And so when she used the term interruptible, that's what she was saying, because again, she did not tie the interruptible language to saying if there is an OFO issue.
Isn't that exactly what she said? We just want to make sure that you guys understand that the Mag 5 is interruptible, subject to the approval or being under that radar with Transco.
But being under the radar with Transco is a concern that they had raised all along, but it's not the language of 9.1. 9.1 requires something much more specific than that. 9.1 requires an OFO that would require Rainbow to be in balance on Transco, and Rainbow was never out of balance on Transco. It purchased the right to be out of balance on Magnolia and Magnolia only. In my remaining 46 seconds, I will only say this on the damages model.
Well, the red light is on, so you have 46 seconds.
Oh, I'm sorry. I'm 50. It's counting up and not counting down. I apologize.
If there are any further questions. All right. Thank you, Mr. York. Ms. Fawn, I believe you have 5 minutes.
I'd like to make 3 points. The first is that this is a case about the construction of the plain terms of the Mag 5. Rainbow didn't point this court to any contractual language that justifies the trial court inserting the term scheduled into Section 9.1. And if it can't do that, it can't win in this appeal. Second, Rainbow said the imbalance is on the Magnolia, not on the Transco. The pipelines are connected. right? If Rainbow doesn't put any gas into the Magnolia, no gas flows into Transco, and then when Rainbow makes a nomination and pulls gas out of the Transco pipeline, there is a physical imbalance between the amount of gas that goes in and the amount of gas that goes out. Again, that was the whole point of the contract. Rainbow wants to be able to take gas out when the price is high and physically put it back in when the price is low.
But the OFO at tab 2 says the type of imbalance that's at issue is due from shipper. Why is that not a single point imbalance?
So due from shipper means that the shipper is shorting the pipeline.
At a single point?
No, at a point to point. So it means that the shipper is putting less gas into the pipeline than the shipper is pulling out at a delivery point. So it is a physical point-to-point imbalance. Because, right, that's what Transco's worried about here. Okay, forget about the fictional scheduling, right? Transco's worried about two things. There's too much physical gas in the pipeline, and it's going to cause a rupture, or there's not enough physical gas in the pipeline, and that means gas is going to stop flowing, and Transco can't make any deliveries to any of its customers, right? Transco's concerned about the physical operation of the pipeline.
Do we know whether section 9.1 is a common provision with, in terms of this precise wording in these sorts of contracts, or is it something that maybe we don't know that, or maybe it's specific to this deal?
It's specific to this deal. There's no evidence that section 9.1 is part of other contracts between the parties.
What should we make of Respondents Exhibit 1 and the statement that the OFO doesn't really affect us now as they've not pulled in the OBA parties yet?
Well, so the first response is Mr. Formel is a gas scheduler. No matter what he says, he can't unilaterally change the terms of the parties' contracts, right? And this court doesn't look outside section 9.1 to witness testimony to interpret its plain terms, whereas here they're unambiguous. The second point is that what Mr. Formel was saying is correct, is that if an OFO doesn't pull in OBA parties, then American Midstream isn't prohibited under its operational balancing agreement from maintaining an imbalance at the interconnect, right? But that's a separate, we're not interpreting the operational balancing agreement. We are asking whether or not Rainbow had a right to submit an out-of-balance nomination under the MAG 5. And it did not anytime Transco issued an OFO to shippers asking them to balance receipts and deliveries of gas. The final point I'd like to make is that Rainbow is taking the position that an OFO had to include OBA parties in order to trigger section 9.1. That is wrong under the plain terms of section 9.1. Again, the parties agree there are two provisions. This is undisputed. The first sentence in section 9.1 applies to a request to shippers to resolve a point-to-point imbalance. The second sentence in section 9.1 addresses an OFO to OBA parties to resolve a single point imbalance. Right, so even if, and we agree, that second sentence is not triggered, the first sentence in section 9.1 is triggered as a matter of law. Thank you.
Thank you. Thank you to both counsel. The case is submitted and the court will take a brief recess.